Hi, good evening. My name is Aachman Shekhar and I've recently cleared the Haryana Judiciary exam. And in this first episode of a multi episode series, I'm going to be talking to you about core concepts for your judiciary preparation. I'll be dealing with several concepts from across subjects which can be helpful for you. And the way that I'll be dealing with them is that first I'll give you a basic overview of what these concepts entail, and then I'll try to answer and I'll try to show you how to answer, how to use these particular concepts when your judiciary mains answers, so as to ensure that not only do you understand the concept fully, but you're also able to apply it in real time to your mains answers that you'll be writing very soon. Therefore, today's topic, without further ado, let's start with today's topic. Today, I'll be talking to you about the concept of attempt in under the IPC and now the BNS. Now, the concept of attempt, as we all know, deals with a variety of factors, but it is dealt with in section 511 and section 62 of the BNS. Now, let's look at the language of section 511 and section 62, because remember this, irrespective of whether your particular state judiciary provides you with a copy of the Bare Act or not, it is very important that you understand and that you retain the essential keywords of these provisions and of these essential concepts that are within the acts. If you notice that section 511, which deals with attempt under the IPC, is materially similar, is the same, is in fact identical as section 62 of the BNS. This means that what jurisprudence was developed for section 511 applies directly to section 62 of the new BNS as well. Therefore, if you've studied 511 once, you will not really have to restudy, or revise section 62. You just need to ensure that you know that now the earlier section 511 is now section 62 within the BNS, right? So now let us look at some of the important keywords and what they indicate within this section. As we all know that attempt under section 511 is the general law of attempt, and as we all know that the principle of law is that special laws or local laws, special laws stroke local laws will always trump general laws, right? For example, when it comes to the prevention of money laundering, the PMLA, the provisions of the PMLA Act, Prevention of Money Laundering Act, will always supersede the concurrent or the similar provisions that are provided for under the IPC. That is because of the fact that special laws always trump over general laws. Specialized laws, local laws will always trump over general laws. Similar is the case here. Section 511 gives a general definition of the term attempt. General provision with respect to attempt. But there are other provisions, such as, most notably, section 307, which talks about attempt to murder. Similarly, there is section 309, which deals with attempt to culpable homicide and things like that. There are various other sections which specifically deal with a particular with a particular kind of attempt. So in those scenarios, this section will apply, because this become a form of a special law, a special provision. Whereas if there is no, on the other hand, if there is no special provision provided for that particular offense or the particular attempt to that offense, then section 511 will apply. So therefore, 511 is more omnibus, in nature, because it includes all attempts to do any of the offenses except the ones that have been specifically excluded through a special provision, right? I hope that's clear. Excluded through a special provision. This is the basic understanding that we have to work with. Section 511 therefore will only apply in those instances where no specialized section has been provided for or has been legislated for that attempt to a particular section. So attempt to murder will always be covered by section 307 and never be covered by section 511, right? Similarly, attempt to culpable homicide will always be covered by section 309 and never by section 511. I hope that is an important distinction, because most of the times the questions that are asked from the attempt part of things involve a case scenario or involve a fact scenario where a person is has either been killed or there is some theft. So in the case of theft, since there is no particular section which deals with the attempt of theft, right? So therefore 511 will govern. But because if let's say there's a fact scenario where murder or culpable homicide is involved, section 511 will not come into the picture. Only section 307 or 309, depending on the nature of injury and depending on the nature of offense, will come into play. So I hope that distinction is clear. But at the same time, the jurisprudence which revolves around attempt is the same, right? The concepts which have been evolved to define and to understand attempt apply across things. The only difference is that if the offense has not been specifically provided for, its attempt has not been specifically provided for, only then 511 will apply. Having understood that, now let's look at some of the keywords of this provision. Attempts to commit an offense punishable by this code. So only those offenses which are punishable by under the IPC and now the BNS. If you we will look at the language of the BNS as well, but since it's identical, I don't think there will be any differences per se in the two texts. Like, so if you identify the language in the IPC itself, that will be equivalent to you understanding and applying the concept of attempt as exists under BNS as well. So punishable by this code with imprisonment for life or imprisonment, any imprisonment for that matter, right? We also know that if it's imprisonment for life, it's deemed to be 20 years, right? This will be relevant in the later part of the section we will discuss. Or to cause such an offense to be committed, and in such attempt does any act towards the commission of the offense. Does any act towards the commission of the offense. This becomes important and I'll just discuss how. Shall, where no express provision is made by this code. See, this speaks about sections 307, 309, etc. Right? Because there, in those instances, special provisions have been made for a scenario where attempt to commit an offense has been committed. Right? Be punished with imprisonment for any description provided for the offense for a term which may extend to 1/2 of the imprisonment for life, or as the case may be, 1/2 of the longest term of imprisonment provided for. So imprisonment for life, if you have to take 1/2 of the imprisonment for life, one of the sections of the IPC which comes in the general definitions clause, I believe, or after the general definitions clause, provides that to compute fractions of the life imprisonment will deem to be of 20 years. Therefore, when you are guilty of an offense for which is punishable by life imprisonment and you've only attempted to commit such an offense, you can be punished with up to 10 years in prison, right? As opposed to that, offenses which are punishable by 10 years, 7 years, 3 years will therefore mean 5 years, 3.5 years and 1.5 year respectively, right? So I hope that distinction is clear. Now, the two important concepts that emerge now after having understood the penal aspect of it, which says that only 1/2 of the punishment that particular person will have to suffer. Having understood that, now let us look at two of the most important concepts that are being discussed in this particular provision. One is attempts to commit. When we are asked to write a short note on attempt, we need to understand what the actual meaning of attempt is, and only then can we write a short note on attempt, because once you're writing a short note, the question demands that you give a meaning of the word attempt, right? So that is one of the key important things. And the other important thing is, does any act towards the commission of the offense. Both of these things are really, really important, right? If you were to now look at section 61 of the BNS, this also provides the same. Attempts to commit an offense, imprisonment for life or imprisonment, cause such an offense to be committed, and in such an attempt does any act towards the commission of the offense, shall, where no. See, this is exactly like word for word the same or identical as the IPC definition. So let's just work with the IPC definition because it's slightly easy to deal with. Also, if you note, illustrations are also identical as 511 IPC. Right? So let's just look at section 511 for now, and you remember that section 62 of the Bharatiya Nyaya Sanhita actually deals with the term attempt. Right? Are there any other sections? No, they're not. Great. So now coming back to the IPC, we'll discuss the illustrations later, but now let us discuss some of the more important factors in the term attempt. I've already prepared my notes, but in the future classes, in the future episodes, I'll be making the notes down with you. Today, for the sake of convenience and for the sake of expediency, I've ensured that all the notes are already jotted down so that you can also take the relevant parts down in your own notes or your notebooks, wherever you're keeping notes. Right? So 511 is identical. 511 and section 62 are identical. Right? I hope that's clear. Now, it says that 511 deals with attempt to commit a crime made punishable under the IPC. And as we've noted before, if you're committed under section 5, if you're convicted under section 511, you will be held liable for 1/2 of the maximum punishment for that offense that you are attempting. Right? This is the penal provision. As mentioned, as understood, as is very clear, this is a form of an inchoate offense. Inchoate offense can also be called an incomplete offense. Attempt is then a form of an inchoate offense. Right? Because the offense itself, the offense that was intended to be done, has not been completed because of certain circumstances or because of certain factors that may be outside the control of that particular party, but it is still criminalized because of certain factors that I'll be dealing with later. But now let us try to understand what is actually meant by attempt. Attempt is something which is more than intention and also more than preparation. Right? Intention is the formation of the idea, or is formation of guilty intent essentially. So let's take an example of you wanting to play football, right? You deciding to play football. Now, when you that idea occurs to you that I want to play football and let me get ready for it, that means that you have the intention to play football. When you lace up your boots and walk towards the field, that would be considered preparation, because you are lacing up your boots, football boots, lacing up your shoes, and walking towards the field would be preparation, right? But the minute that you kick the ball for the first time, or you attempt to kick the ball, you try to kick the ball for the first time, that would be called you attempting to play football, right? So intention would be you making up your mind that I want to play football. Preparation would be you preparing by wearing your shoes and walking towards the ground, and attempt would then therefore be the final step in this chronology where you actually try to kick the ball, right? And you actually try to start playing. That would be then attempt. So this therefore is clear to us that attempt is more than intention and more than preparation. This factor is important because most of the practical type questions that are asked from this particular provision are a test of your understanding of the concept of intention, preparation, and attempt. More specifically, they try to test your knowledge about your understanding about the difference between the concepts of preparation and attempt. Right? So preparation is something is things that you're doing to ready yourself to be able to commit an offense, whereas attempt on the other hand is the actual act towards the commission of the offense. Right? We will try to understand this distinction by some of the practical examples that we'll solve in the later part of the class, but I hope you realize that the difference between preparation and attempt is very crucial for you to actually understand the meaning of attempt and to be able to correctly apply this concept to the many practical questions that may come out of this subject in any of your papers. Right? This therefore becomes relevant not only from the mains perspective but also from the prelims perspective, and I hope you are able to draw the distinction between preparation and attempt in your mind. Right? Now let us look at what the formal definition of attempt can be said to be. It can be said to be that direct movement towards the commission of the offense. That would be one of the best definitions. Direct movement towards the commission of the offense, which means that you do an act, doing of an act which towards required for committing the offence and such act must be immediately connected to the offence, right? This fact also comes out from this particular line which is used in the section, which says that does any act towards the commission of the uh, offence. This indicates to us that direct movement towards commission of an offence is something which is covered under the attempt. So therefore, when you do some act which is towards the commission of the offence, not just you preparing or making yourself ready to commit that offence, but actually starting to commit that offence, that particular act would be said to be attempt, right? And this, what this does is that it ensures that there is mens rea present, and also there is mens rea and also some actus reus. So for example, in the football example that we took, the mens rea, even though playing football is not an offence, but let's assume that playing football is an offence for now, the mens rea in that example would be your intention to play football. If playing football is an offence. Or let's say if watching a movie is an offence, right? Watching a movie is an offence. So in that scenario, your mens rea would be to intention to play football or to watch a movie, right? That would be the intention in the scenario where playing football or watching movies is an offence under the code, right? Now your actus reus, first let us look at what the preparation for these things would be. The preparation for both of these things would be wearing your football shoes. They're called studs. Wearing your football shoes, right? Or in the case of a movie, finding the remote for the TV, something like that. Now these things are preparation, and preparation usually is not made culpable. Only in certain cases such as dacoity is preparation made culpable, and in some other class we'll also discuss why preparation for committing dacoity has been made punishable under the IPC. But generally the general principle of law is that when it's preparation, it will not be culpable, and therefore you cannot be held liable even under section 511. On the other hand, to be held liable for attempt under section 511 or even section 307 as the case may be, the actus reus which is required is you trying to kick the ball, right? Or you trying to play as a goalkeeper, whatever, right? Or you switching on the TV with your remote. Because both of these actions are a direct movement towards the commission of the offence, in this case where playing football and watching movies has been made an offence, right? I hope such a day never comes, but let us say hypothetically playing football and watching movies have been made an offence. Therefore, in those scenarios, trying to kick the football or switching on the TV to watch the movie will both constitute as attempts. And since both mens rea and actus reus combine in these instances, that particular person will be held liable for attempt. Right? This is the basic explanation, and this is the basic understanding of attempt. If you were to explain your answer, if you were to broaden your answer in such a manner, I believe that this will really help you. And because at least for me, this strategy has really held my stead in a lot of exams, and I was able to explain complex concepts through these thoughts of through these line of thoughts across which I penned down across a lot of mains exams. So therefore, I hope these these ways of understanding, this line of thinking of understanding attempt can also be helpful for you. Now let us look at why what exactly is the test for attempt now. As you would have noticed that this now is the test for attempt. Does any act towards the commission of the offense, right? Now this standard, this also involves, this also tells you a lot about what the standard for judging attempt now is, right? Because earlier what used to happen was, in the British time before the IPC was codified, the act that was used was the penultimate act test. This was also used in India for some time, but it was eventually done away with because of the language of the act, which says this: does any act towards the commission of the offense, right? So if you were to look at that, the first test that was to be used was penultimate act. What penultimate act means, that penultimate is just before the final thing. So let's say if you were to if you're in school, then the 11th grade would be the penultimate grade because 12th is the final grade. Similarly, if you're in college, fourth year is called the penultimate year, whereas fifth year, which is your final year in college, or if you're in the 3-year law course, then the second year is the penultimate year and the third year is the final year. So penultimate literally means that which precedes the final or the ultimate thing. That which precedes the final slash ultimate act, right? That is what is meant by penultimate. So earlier when the penultimate test was used, it used to say that locus penitentiae, which meant that does the person have the opportunity to repent, the chance to repent, which meant that only those attempts were criminalized where the person could not go back, right? So if the person could not go back, let's say if you were to pull the trigger, if let's say you wanted to shoot someone on their head to kill them, and you pull the trigger, only once you pull the trigger would you be responsible for attempt under the penultimate act test. Because once you pull the trigger, it is out of your control whether or not the gun will be fired or not, right? On the other hand, this test has also been followed in the landmark case of Reg versus Taylor, R versus Taylor, and this is a very classic case, locus classicus, on the penultimate act test, and you can have a look at it anyways. But now our jurisprudence has shifted towards a more pragmatic and a more and an approach which is closer to the actual text of the provision, which is the proximity test. Because if you were to notice, the language used in the Bare Act, it says does any act towards the commission of the offence. It does not say does the penultimate act towards the commission of the offence, or does an act just one step short of the commission of the offence. It says does any act towards the commission of the offence. What this means is that the penultimate proximity test standard is now applied instead of the penultimate test, where you look at whether that particular act that you're doing is close to or proximate to. Proximity means closeness, right? If the particular act that you're doing is close to the actual offense that you intend to commit, then under the proximity test you will be held liable, right? So it does not need to be the immediate act or the act immediately preceding the offense itself. It can be some other act also which is in line of you attempting the offense. So for example, in the example that I used to explain the penultimate act test before, where I said that if you were to point a gun at someone's head and pull the trigger, that would make you responsible, that would make you liable under the penultimate act test. On the other hand, in the proximity test, if you were to pull out the gun and point it towards someone, that in itself would also amount to attempt, because you've done something which you've done an act which is towards the commission of the offense, and this act itself is very proximate or next to the actual offense itself, and therefore you will be held responsible for the proximity test. And the landmark case for proximity test that you can use or that you can have a look at any time is the State versus Mohammed Yaqub case. This is a very famous terrorism related case, and everyone is recommended to go through it, because not only does it deal with certain important principles of the IPC, but it also deals with certain important principles of the CRPC. So this, I would definitely recommend that you read this particular judgment. If you can't read the entire judgment, I would definitely recommend that you have a look at the summary of this judgment and the summary of the holdings that the Honorable Supreme Court passed in this particular judgment. Right? Now let us try to understand why, no, now let us try to understand the two illustrations that are given in the section. These illustrations are also the same as are given under section 62 of the Bharatiya Nyaya Sanhita. Now, if you were to understand this, the first illustration says that A makes an attempt to steal some jewels by breaking open the box and finds after so opening the box that there is no jewel in it. He has done an act towards the commission of the offence and therefore is guilty of the offence under this section. Because he has done an act towards the commission of the crime, because he's... So, for example, in the penultimate act test, in this particular scenario, in the penultimate act test, what would be the locus would be when he's actually picked up the jewels and put them in the pocket. If he's picked up the jewels, then that would be said to be penultimate act, because now he just has to escape and he just has to move with those jewels in order to, in order for it to be stealing. But on the other hand, in the proximity test, just by breaking open the act, just by breaking open the box, that person has now become liable, because breaking open the box is closely related to the ultimate offense, even though this might not be the penultimate act which is required to be done to commit the offense of stealing. Right? So similarly, in the illustration B, you may see that A makes an attempt to pick the pocket of Z by thrusting in his hand into Z's pocket. A fails in the attempt in consequence of Z having nothing in his pocket. A is guilty under this section. This also tells us that attempts which are impossible are also culpable. Even though the thing could not have been done, the person will still be held liable for doing such a thing. A good example of this, and an illustration that often comes in the exam as well, is that a wife wanted to poison her husband, thought that a particular white powder is poison. She mixed that alleged poison with the water and gave it to her husband, right? But for reasons unknown to her, that particular white powder was not poison, but in fact it was sugar or salt. Therefore, in this scenario, even though the husband will not die, because the water is not poisoned, it is in fact sweetened, or it has been made salty. But because the wife thought that she was taking the act towards killing her husband, and she's taken steps towards killing the husband, it is her intention that will determine whether or not she will be held liable for the offense of attempt. So even though the husband dying from such an act was impossible because of certain circumstances, because the wife made the intention, that is, she had the guilty intention or the guilty knowledge, which is covered under mens rea, and she also took certain steps towards committing that particular offense, which is mixing what she thought to be poison in water and giving the water to the husband, would make her liable for the offense of attempt to murder, which is covered under section 307, or if it can be said that attempt to do culpable homicide, which is covered under 309. So both impossible attempts are also made culpable in addition to the possible attempts, because they evidence mens rea plus actus reus. Remember, mens rea is always judged on the standard of what the accused thought the situation to be, and not what the situation actually was. If the accused thinks that doing certain thing would be an offense, if the accused knows that doing certain thing would be an offense, that person would be held liable for the offense that is being committed. However, on the other hand, if a person is not aware of the fact scenario which makes the particular act an offense, that particular person cannot be held liable for that offense, because no mens rea can be said to have existed. Right? I hope that's clear. Now let us look at what are the reasons why attempt is made an offense in the first place. I hope you've understood the penultimate act test and the fact that it's been discarded away with in favor of the proximity test. I hope you've also understood the presence of both mens rea and actus reus within the larger, broader definition of attempt itself, and the basic meaning of what it's meant to be, what means or what constitutes an attempt. Now let us look at why attempt is made punishable. To understand this, you need to understand that any attempt or any offense creates alarm. Not only does it create alarm within the state, because it shows that the state had failed to prevent this offense. Usually, in attempts, what happens is that because of certain extraneous circumstances or because of certain unforeseen circumstances, the offense itself is not complete or is not successful. Therefore, what this means that while the accused was unable to carry out his intention to commit the offense that he wanted to, it was also indicates the failing on part of the state to have prevented that offense in the first place. So it creates an alarm in the mind of the state that we should have been more vigilant, or we should have taken the right precautionary measures to prevent such a attempt from happening, right? So it not only creates alarm in the mind of the state, but it also creates alarm in the mind of the victim, right? This is important to understand because the effect of an offense is not only physical. If you punch someone, not only their physical health will be damaged, or they will not only suffer physical harm, but they will also suffer mental harm. Because let's say if someone breaks into your house and tries to steal something, not only will you be robbed of your possessions, but you will also be robbed of the comfort that is associated with your house. You will feel that your house is not safe anymore, and therefore that mental disturbance will happen. That happens in case an offense is successfully done or unsuccessfully done, because in an attempt as well, the injury to the mental stability, or uh, uh, injury to the sense of safety that a person has is present, right? So it attempts strike fear in the hearts of the persons that they're attempted against, and therefore the law ensures that such an offense which has both the essentials of mens rea and actus reus are not gone unpunished, because they are creating alarm and they are injuring the psyche of the people who they are being uh, perpetrated against, right? So this therefore is also a limb of preventive criminal law, because by preventing or because by punishing attempt, or the state ensures that there is no that people are disincentivized, or people are afraid or deterred from committing such offenses in the first place. Then the second thing that is happening is that it demonstrates the guilty mind of the person, right? Because you are taking certain actions, that demonstrates that you had a guilty intention in the first place. So not only did you cause some injury to the other people, but you also had a guilty intention in the first place, and that is the only reason why you attempted to do a certain act, right? And therefore it can be said that both actus reus and mens rea are existing in the same thing, and when both of these things exist at the same time, the person can be held liable for the offense. Now it will not be right to hold the person liable for the offense itself when the results required to constitute that offense had not taken place, but at the same time, in the interest of justice and overall well-being of the society, the legislature has said that whenever an attempt to commit an offense is done, that person should be held liable for one half of the maximum imprisonment, or one half of the maximum sentence that is prescribed for that particular offense, right? I hope that's clear. Now now let us look at what are the things that the court looks at when it's deciding whether or not attempt has been made out, and when what are the things that you should also include within your answer when you're answering on the aspect of attempt being made out, or attempt or answering a practical question involving the question of attempt. So in the landmark case of Abhay Mishra versus State of Bihar, the three important factors that are required to be proved in order to constitute attempt have been mentioned. And these three important factors are the following. All necessary steps have been taken, that is, actions required to most actions, sorry, most necessary actions have been taken. All would be the wrong word. Most will be the right word. Most necessary actions have been taken. That is prerequisite number one. Second is clear evidence of mens rea. you can only hold a person responsible for an offense when there is some mens rea by doing certain acts in a certain manner. That is evidence enough of mens rea, but there should be some evidence suggesting that that person had a guilty mind, and only because of that guilty mind or guilty intention did that person commit do certain acts, right? So clear evidence of mens rea, most necessary actions have been taken, and that the act which is taken is proximate to the offense intended, right? That is what differentiates it from preparation. Attempt is proximate, whereas preparation is not. Let's say in the wife trying to poison her husband example, if the wife has bought poison, right, from the market, that would be attempt. Buying poison, so let us look at the chronology, right? The wife intends to poison her husband. This is intent, right? Then wife purchases poison from the market. This is also preparation. Now, importantly, I want you to focus on this. Wife mixes the poison with some water, with water to be given to the husband, which is to be given to the husband. This, I would argue, is also preparation, because as long as the water is not sent to be given to the husband, it can only be said to be preparation. But now, when the wife gives the husband water or places water before him or asks someone else to give that water, only these scenarios will constitute attempt, right? So I hope the distinction between preparation and attempt is clear, right? So applying that here, it means that act must be proximate to the offense intended, right? It need not be penultimate, because in this scenario, even if she gives the husband the water or she asks someone else to give the water to the husband, she can always go to that person and take the water back. So therefore it cannot be said to be penultimate, right? But it is proximate because it is likely in the course of events that are happening that the water will now be given to the husband. Therefore I hope that the proximity penultimate test distinction is clear in your head, right? So these are the three factors that have to be looked at in order to hold someone liable for attempt. So whenever a question comes from this particular part, I want you to first explain what the meaning of attempt is. Then you look at what the crucial parts of section 511 or section 62 BNS, depending on what the notification, what that particular notification asks you to do. I want you to highlight the three relevant the relevant keywords from the section, which are attempts to commit, does any act towards commission, and that 1/2 of imprisonment will be done. All three keywords should be mentioned, and then you look at what the series of events is. That first intention is made, then preparation is done, and then only attempt is followed, right? Because attempt is more than preparation and more than intention. Then you explain what the relevant test. No, first you explain why attempt is made punishable, and you can talk about one, that it is a clear intent, that it strikes fear or it creates alarm in other people, and also it is a clear evidence of the guilty mind of the accused. So in an attempt, both actus reus and mens reus coincide, and therefore criminal liability can be imposed. Then you explain to them that the test has shifted from the penultimate act test to now the proximity act test, and for that you can always use this case as well as the landmark case of Abhay Anand Mishra versus State of Bihar. Now, if a practical question arises, then I would recommend that you use these three practical points to explain your to explain and to apply the law of attempt to a particular fact situation. I hope all of these things are clear. So, having said those things, let us now look at some of the practical examples that may be asked from you, there to ensure that you are able to understand what is and what can be some of the questions that are asked from this particular section. So, as you can see, this was a particular question that was asked in Punjab in 2006, but this question is repeated across states. So, understanding this question and understanding how to answer it will really help us to uh, make a better case for ourselves and get better marks in the mains itself, right? So, as I discussed before, you discuss the ingredients that we mentioned in the keywords, and you talk about what the meaning of attempt is while answering this question. That is the theoretical aspect of the answer. And then to answer the other thing, the following part of the question, which is state whether in the following situations any offense or an attempt to commit an offense under the Indian Penal Code is made out. So the first part is a wife intending to cause the death of her husband mixes sugar in his tea, thinking that it was poison, and gives it to the husband. Now, since the wife has given it to the husband, that means that it's a proximate act, and therefore she can be held liable for the attempt. And even though she was mixing sugar, and therefore the attempt is an impossible attempt per se, but because there is a clear intent, there is a clear evidence of her own mens rea, the particular wife, as we discussed in the example before as well, can be held responsible for the attempt. But since this will be attempt to murder, you will hold her responsible, you will hold her liable either under section 307 or under section 309 based on your understanding of these offences, and not under section 511, because section 511, as I mentioned before, only deals with certain parts, only those offences whose attempts has not been specifically criminalized under the code. Right. The second is a man intended to kill Gopal strikes Gopal's body with a heavy rod while he was lying dead in the room. This is again a form of an impossible attempt, because the thing that he seeks to do, the thing that he is trying to do has already been done. So therefore, his act of hitting Gopal is not making any effect. But to his mind, the mens rea has to be looked at from the perspective of the offender, and not from a third perspective, right? So from the offender's perspective, he thought that the person is lying down, and therefore in order to kill him, he started beating him. So therefore both mens rea and both the actus reus exist in this particular scenario, and therefore that person can be held liable for the attempt, even though this would be also an impossible attempt. But as you know, as you've noticed before, that both the illustrations, illustration A and illustration B of section 511 of the IPC, and now section 62 of the BNS, deal with such impossible attempts, and therefore impossible attempts can be made punishable under the Act. Now, the third part is A intending to blast a bridge carries a bomb near the bridge. He was awaiting the orders of the gang leader to carry out the blast. Before that, he is arrested by the police. Now, in this scenario, you understand that this particular act, waiting for the commands of his higher boss or whatever, of his chief, is not proximate enough, because as you remember, if you remember the fact scenario of the wife mixing sugar for her husband, we discussed how just mixing poison in the water is not an attempt. Being present at a site that you want to bomb is not an attempt per se, it is only preparation. Only that when you plant the bomb or when you hand the poison water to the husband can it be said to be a proximate act for you to come under the definition of attempt. And therefore, only in these two scenarios where you've handed over the glass to your husband or you've given the glass to someone else to give it to your husband, can you be held responsible for attempt, because that act would be called a proximate act. And in this scenario, only when the bomb is planted can that particular person be held liable for attempt, and not otherwise, because right now the act that he's done is only that he's ready to prepare the bomb, he's made all the preparations required for him to plant the bomb, and he's still waiting for the instructions from his boss. And therefore the act itself, the act of waiting at the bridge in order to plant the bomb is not an attempt, it is rather preparation. Only when he plants the bomb actually can it said to be an attempt. I hope that distinction is clear, and I hope that that makes it clear how attempt really functions, and the difference and the distinction between attempt and preparation becomes clearer. So that was just the first episode of our multi-episode series on the core concepts of judiciary and of core concepts of law required for the judiciary exams, and I hope this was helpful. In further classes we will continue discussing more such concepts, and I'll also try to attempt to apply them to the practical scenario so as to ensure that you not only understand what I'm speaking, but you're also able to apply your knowledge readily. Thank you. Bye. See you in the next class.